Hello, everyone. Thanks very much for joining me on this number 2 in a series of 5 conversations with attorney mediator, Rachel Virk. Hi, Rachel. How are you?
Hi, Natalie. I'm great. How are you doing?
Good, thanks. So, Rachel, I want to ask you maybe the super obvious, but the name of your book, The Four Ways of Divorce.
Yes, this is the book, The Four Ways of Divorce, on Amazon.
There you go. So you can just search that in Amazon and pick up a copy for yourself. But could you break down for me what are the four ways of divorce and what's the difference between each of those four ways? Am I asking a question that's too broad or?
Well, we'll try to narrow down the answer somewhat to a more concise definition, but basically it all boils down to, do you need to stand up and fight it out, or can you and your ex-to-be sit down and work out a new life plan, a new two-home family? And the stand up and fight it out would be through litigation or a very aggressive adversarial negotiation. And the sit down and work it out would be through either the mediation process or the collaborative process.
Okay. So basically the answer is it depends. It depends on where I might be with my soon-to-be ex-spouse, right?
It really has to do with, do you need to stand up and protect your physical safety, your future financial security, your business or professional practice, your assets, or your children. And sometimes it is necessary to take an aggressive and strong stance, and sometimes it's important to jump right into court. That is not usually the case. More often than not, people can at least start the process by trying to work out an agreement either through the mediation process or an adversarial negotiation process that could be amicable, or through the collaborative process.
Okay,
And,
so
go
yes.
ahead.
Well, so we hear a lot about unbundling. Where does unbundling fall? Is that a collaborative divorce?
I am not familiar with that term, Natalie. What do you mean, separating out issues of property or support?
It's become a thing in the media here in Europe about unbundling. And so what my takeaway is, and people, of course, in the comment section will correct me, is that is part of the collaborative divorce process, wherein it's very amicable and they're very politely just undoing all of the things that they've put together as a couple, home ownership, accounts, child custody, all of these kinds of things. But I think that when people are using that term, it falls under the collaborative section, I think.
Well, let's define things a little bit, okay? So litigation means going to court. And here in the US and here in Northern Virginia, where I litigate, we have an option of going to the circuit court, which is the divorce court, and filing either a divorce suit or something called a suit for separate maintenance. Sometimes for religious reasons, a person doesn't want to file a divorce suit, but they do want to have the judge resolve matters of custody, visitation, support, so they might file a separate maintenance case. Or there's an option of litigating in the juvenile court, which has some positive components and some negative components. So litigation means going to court, and a cynical way of describing that would be to say it's two lawyers or two parties putting on a show for a judge. They see a snapshot of your life and they make decisions based on that brief performance that will profoundly affect you, and you're stuck with that result. There's nothing you can do about it. And in my view, litigation is a very old-fashioned way to resolve a dispute, especially a family law dispute. It benefits the attorneys every time. There's a lot of money and fees to be had that goes to the law firms instead of the families, the litigants, family. But sometimes you do need to stand up and fight. Sometimes you do have to protect yourself. So off you'll go to court. If a lawyer tells you you have a really strong case, it means that there's some statutory or case law they can argue that is favorable to you, and your ex-to-be's attorney is also telling your ex-to-be that he or she has a very strong case, because they can also come up with some good arguments, statutory support, case law support, because lawyers can argue both sides of anything. So litigation is one option. Sometimes it's necessary. It is expensive. Another option is negotiation, and that can be either adversarial or very amicable. And what negotiation is it's each party has a lawyer. One lawyer writes up an agreement, sends it to the other side, and then let the games begin. Either red line, track change, agreements go back and forth, or there's lots of faxes and emails and discussion. There might be a four-way meeting or two, and there's a lot of back and forth, back and forth, back and forth until finally a settlement is reached, the agreement is finalized, and that process can be very amicable, very caring, very respectful, or it can be more of an adversarial negotiation where there's a lot of threats and, statements of what one side's going to do to the other side. But often people really kind of know they're not going to go to court. They don't want to go to court, but they're doing a little bit of posturing. For divorces that are very amicable, a lot of people will mediate. There are different models of mediation. When I conduct mediations as a mediator, it is me, an impartial, neutral mediator, helping two people create their new life plan. And it's very amicable. They're getting information. They're hearing options. We're discussing. It's not played out in the public for an audience to sit and watch in a courtroom. It's behind closed doors. We can bring up things that you can't bring up in court, religious considerations, other things that judges are not allowed by the Constitution to rule on. So mediation is an amicable way. And as I mentioned, there are different models. The one model I just mentioned with one neutral mediator and two parties. I've done some mediations where each lawyer has, or each party has a lawyer, and then the mediator is kind of supervising this whole thing between both parties and two lawyers. There's something in Northern Virginia that we call mediation. In my mind, it is not mediation. It's facilitated negotiation, and that's where usually a case is in litigation, and towards the end of the litigation, after all the information has been exchanged, the two lawyers say, okay, let's hire a retired judge to help us, quote, mediate, and they are usually put in different rooms, and the mediator judge goes back and forth between the two rooms, trying to help the two sides work out some sort of agreement, but they're never really in one room discussing, working out, sharing information and perspectives. But that is called mediation here, although in my mind it's not. It's facilitated negotiation because it's a negotiation. So there are different ways to mediate, but generally the idea of mediation is that the two parties are working things out with help, okay? And the kind of mediation that I would conduct is me as mediator with two parties in my office. The fourth method of working out the terms of a divorce is something called the collaborative process. And that process is a process where each party has to hire an attorney trained in the collaborative process, okay? And there is a participation agreement that is signed where the parties acknowledge that if they can't settle their case and it goes to court, they have to go hire different brand new lawyers. They can't use those lawyers in court. That is what makes the case collaborative. There are a lot of lawyers who will see a party, and in Northern Virginia, our ethics requirements are such that lawyers are supposed to and are required to tell new clients about the different methods of resolving their dispute, including what's called our alternative dispute resolution methods, like mediation and collaboration. I think, and there's a sense that a lot of lawyers aren't fans, excuse me, of the collaborative process because they feel that, well, that would be a disservice if they have to start over with new lawyers. So it's not generally recommended. And there's a misunderstanding of what collaboration is all about. The formal collaborative process is where two parties, a husband and wife, hire lawyers and they sign a participation agreement that says we are going to sit down and work this case out. We're not going to pretend to go to court. We're not going to make threats. We're not going to take advantage of each other. It's not about grabbing all the marbles. It's about figuring out how to carve up this pie in a way that makes everybody happy as a family moving forward. And with the collaborative process, there are usually 2 or 3 meetings. There's only so much to talk about. Depending on how fast or how slow people want to go, typically it's about 3 sessions where we talk about all the things that have to be discussed and an agreement is written up. If experts have to be hired to value a business or to appraise properties or to conduct any one of a number of financial analyses, we hire one financial person instead of each party hiring one. And there are what are called neutrals, mental health and financial neutrals, also trained in the collaborative process that know how to participate in that process. Some attorneys, like myself, favor the attorney-only model of the collaborative process where the parties can meet with other experts, or maybe we bring in an expert briefly, but they're not there at every single meeting, and it's not a requirement that they be at every meeting. Other attorneys favor what's called the team approach, where they will say every collaborative case has to have a neutral mental health professional for each party and maybe the child, a financial neutral, and you might find all of a sudden that you got 3 professionals plus 2 lawyers, plus 2 parties, and you're trying to set up meetings with mental health coaches for each, coach for the child, financial neutral, 2 lawyers, 2 parties. The cost gets very significant. I'm not a big fan of the team approach. It is sometimes a good thing, but it's not a given that it should always be a requirement. We give people the option of saying we can bring in this or that, or these or those people. Sure. Here's the benefits, here's the drawbacks, and let's decide how we want to go. But almost wrapping up this very long answer, one last point I want to make. The collaborative process, again, is when each side wants to sit down and work things out with a lawyer in the room. In my personal experience, if someone is able to articulate their needs and assert themselves, especially the way I mediate, where I make sure everybody is fully informed, they don't necessarily need to have 2 lawyers in the collaborative process. They can be just fine in mediation. My personal view is that collaborative is very well suited to a very narrow subset of individuals, and there's 2 types. One type is the kind of person, male or female, I've had both, who are not able to stand up for themselves in a room and say what they need and want. They're cowed by their spouse, or they're just too insecure, or they're scared, or they just don't know how to assert themselves, or they're not confident that they know enough, and they just need somebody advocating for them and advising them, speaking for them. They don't want to go to court. They want to work it out, but they're not able to do that on their own with a mediator. They feel like they can't assert themselves. There's another kind of collaborative sort of a case, and these are people who just would never be able to go to court. They're similar to the first group of people, but these are people who, if they can't mediate, they sure as heck are not going to be able to go through the rigors of all the formal paperwork and motions and hearings and temporary hearings and a final hearing and prepare all their testimony and sit in the courtroom and look at a judge and look at a lawyer and look at their X2B and testify in court. They just can't handle that. So these people who just can't manage to go to court and their spouse is not trying to take advantage of them, that's important, or they just kind of feel like they'd be more comfortable having a lawyer in the room. That, I think, is a situation very well suited to the collaborative process where we all sit down and we say, let's work this out. Let's figure out how to do it. What's going to make the most sense for everybody? Let's try this for a couple of months, see if it works. If it doesn't, we can try something else. That's something you can't do in litigation. You can do in mediation. So after denial, bargaining, grief, anger, acceptance, and get informed comes make a plan. The first plan is, how do we want to resolve this? litigate, negotiate, collaborate, or mediate. The next make a plan is, where do I want to be 1 year, 2 years, 5 years, 10 years from now? So stand up and fight it out through litigation or very aggressive negotiation, or work it out through non-adversarial negotiation, mediation, or collaboration, and collaborate either with the attorney-only model, using experts as needed, or the team model where you bring in a whole host of people and it's a whole team effort.
Okay. I really like how you've defined the differences, the legal differences, I don't know, maybe the word is the cultural fabric differences between each of those processes. I've got 2 quick questions.
Your questions might be quick. Unfortunately, my answers are usually long.
But I like your answers. You know, these are important issues, and you know, we want to give people correct and good information. So earlier you said, and I don't know if this makes a difference or not, but you said between a husband and wife, these are the issues. Does it make any difference if it's wife and wife, or husband and husband, or husband and wife?
The issues are exactly the same, and as a mediator and as a professional, it's important. I made a terrible mistake in one case where I said something to somebody who was transitioning, just not acknowledging the person that they were in the process of becoming and thinking them as more the person they were no longer.
Right.
So it's important for people who are in same-sex marriages or other non-traditional paths to understand that for some of us, there are some things that we have to get used to. But for same-sex divorces that I've worked through, it's really interesting. I don't want to talk about particulars because it's very important for us to protect our attorney-client relationships and all this. So I will just speak in general terms of just general conglomerate of clients that I've had, but sometimes the parties don't understand that it's the same as with everybody else. I had a case where a lady was kind of floored to realize that her spouse could go after her retirement. You know, she was talking about this or that little thing, but then it turned into, well, you know, this other kind of stuff could happen. That was more of an adversarial thing.
Right.
In a mediation, unless we have a significant number of same-sex marriages, it's important for us attorneys and professionals to go through our forms and make sure that we're not saying husband-wife. You know, we have to make sure to phrase things with respect, you know, to make sure everybody is comfortable and happy with the terminology. But so that's more of a method thing. But as far as
the processes remain the same.
Process is the same.
Just exactly the way you defined them earlier.
And the information is the same. There's nothing different. And in fact, one of the collaborative cases that I had involved a lot of issues like this. And it was good because we could approach those issues with a lot of sensitivity. We could talk about things that you're really not going to want to talk about in court, in a public hearing, and have a judge decide. It's better when there can be a discussion. And it can be done with respect and dignity and sensitivity.
Right.
And that's not what happens when you go to court.
So that leads me to my next question. I hear all the time when people are talking about getting a divorce, and I hear this. So I would like for you to correct me if it is a wrong assumption. The conversation I hear all the time is that everything in a mediation is confidential. Is that true or false?
There's 2 aspects to that. Here in our courts, in the juvenile courts, because my personal view is that judges don't necessarily want to hear cases because the dockets are very, very crowded. So there are a lot of barriers that are put up before you ever get your final hearing. There might be a first return, and then there might be a status conference, and then there might be a pretrial conference, and then maybe you'll set your trial date. And before you can do any of that in the juvenile court, there is a mandatory referral to mediation screening unless it's inappropriate due to a restraining order being in effect or some other situation like that. And this is a screening to tell the parties here in Northern Virginia juvenile courts, hey, there's a court certified mediator who may not be a lawyer who can sit down with you, and for $100 for the case for support, $100 for the case for custody, can help you work out the matters before this court for custody and support, because our juvenile court does not deal with property, the house, cars, things like that. Who pays the mortgage necessarily? It's going to be child support, spousal support, and custody. So people can choose to participate in that mediation, and if they do, start it, but one of the parties decides, oh, this is all ridiculous, I'm not going to agree to this or that, and they storm out. Whatever happened is confidential, and the mediator can't report back to the judge, this person stormed out, that person's unreasonable, this one won't do what they should. So in that regard, the notes and the conduct of the notes of the mediator and the conduct of the parties is confidential. The mediator by statute can really only report as to whether the mediation was successful, and if it was, here is the form they filled out, and they're kind of a creature of those forms that talks about those issues. That's in our juvenile court. If someone hires a private professional mediator like myself, we're going to sit in my law office and we're going to talk about all these very private things, and it's done not in a courtroom where anybody can walk in and sit and listen, but at the end of the day, I'm going to write up a document, and that document, which is a settlement of a case either party could bring for custody, support, property division, debt division, that document will become part of the court records filed at the courthouse. Now, there's some limited things we can do to put certain information behind private addenda, or to say this part won't be filed, but the parties will hold on to it. And in extreme cases where there's good cause, we might be able to seal a file. Another favorite method is if someone lives in one county here and the court personnel knows that party, maybe we go file in some faraway county, because we can file anywhere if it's by agreement. Venue is permissible anywhere in Virginia as long as it's not going to be contested to bring a case to the preferred venue. So we might file a case in another county where people won't think to look at it, if there are no children especially. But generally, a mediated agreement will be filed with the public records of the court. There has to be good cause to seal that file, because someone is a public figure perhaps, but generally that isn't necessarily a good enough reason. There has to be a reason to make something private.
Okay, all right. That's a lot of information, but I think that now we've all got a pretty good handle on the 4 primary ways that a divorce can come about. It is something that you really, really have to consult a professional about to make a decision, because it seems to me that regardless, you choose litigation, mediation, negotiation, or collaboration, they all have their pluses and minuses, but they all need to be really carefully vetted, so that, because this is a forever solution.
Well, if I could interrupt you.
Yeah.
One might start with one process and move to another process. You might start mediating, it falls apart, which it won't if you want to work it out. But if it does, then you might go to a negotiation, or you might start litigating, and then after a temporary hearing, you realize you got to stop fighting, and then you sit down and you maybe mediate with a retired judge, or you might go off to mediators and come back to your lawyers. I have never had a collaborative case that didn't go to resolution, so pretty much if you really want to collaborate, I think there's no reason you're not going to finish that. And with mediation too, if you want to sit down and work it out and your spouse does, there's no reason that you can't. But you might start negotiating and you wind up in litigation, or you might start litigating, but then you can negotiate a settlement. And that's the more common scenario, because 97% of all civil suits, divorce suits, Northern Virginia divorce suits settle. Only 3% get litigated. So it might start off, it's just a matter of how far down the process are you going to go before you settle. So again, often we'll start litigating and then we'll negotiate a settlement. Or maybe we start negotiating, it doesn't go anywhere, you wind up in court, and then maybe go back to negotiation. A lot of it has to do with how strong your position is and what strategy you are employing.
Yeah, but again, that's why you need to hire a professional. You know, I'm sure that your clients have a lot to say about what process they think is best for them, but it really is important to have someone who can evaluate a case and a situation and help them make that decision, because again, this is not a decision that, you know, you step into lightly. You know, dissolving a marriage is a big deal. And there are super important decisions and negotiations that, you know, that we all have to go through. So thank you so much for sharing with us those 4 basic ways that are, you know, in your book, The 4 Ways of Divorce, which again is available on Amazon.com, everyone. There it is.
It's all about, can we sit down and work it out, or do we need to stand up and fight it out?
Right, absolutely. And of course, Rachel has a really robust website with lots of resources that are available for everyone to look at. Rachel, can you real quick give us your web address?
Virk-law.com, and there's a page there on how do you tell the children, a little 2-minute video with a script of what to say to them, and a lot of resources about, don't forget, your kids are going through this divorce too.
Exactly right. Such a good point to make. So listen, everybody, I will put Rachel's book link and the link to her website down below in the description box. And if you haven't already, subscribe to the channel, like the video, or share it if you or someone you know is in this particular situation and needs some assistance. Thanks for watching, everybody. Be good humans.